Good afternoon, everyone. I want to begin just by introducing myself and my fellow group members. My name is Joe Maye, and to my left we've got Rachel Askinazy, Michelle Bleda, and Glenn Hudson. And today we're going to be discussing malicious prosecution and relative to that cause of action, how you can protect your client from liability, how you can protect your firm from liability, and how you can protect yourself as an attorney from liability, as well as from professional misconduct and discipline. To begin, I just want to give y'all a general hypo just to kind of phrase what we're dealing with. Let's suppose that one of your best clients comes into your office and he's distraught, as he almost always is for some reason. He explains that one of his business partners owes him money and he's yet to be paid. Now this occurs all the time. These two partners are always going at it over getting paid and paying the other, and usually it results, it resolves itself pretty easily without having any action being taken or any kind of process. But at this point, your client has had enough and he wants to file criminal charges against the partner associate. Now, you understand your client is upset and you think he might possibly have a charge, but you're not entirely sure yet. But you don't want your client to think that you're not completely behind him. So what do? It's our hope that with our presentation today, you'll have a strong grasp of the charge of the claim for malicious prosecution, how it can affect your practice, and how, as an attorney, how you should conduct yourself to avoid liability and professional misconduct. And before we dive into the meat and potatoes of everything, I want to just give y'all a roadmap here of what we're going to cover and the order we're going to cover it. Just so you know, we're going to cover what exactly is malicious prosecution, what is malicious prosecution versus abusive process, which is a very similar claim, malicious prosecution in relation to debt collection, attorney liability, special advice, and a checklist or steps that you can take to alleviate risk as you as a lawyer. And with that, I'm going to pass it off to Rachel.
As Joe mentioned, we're going to be discussing the nuts and bolts of malicious prosecution. So first, I'd just like to start with a brief definition. Malicious prosecution is the initiation of an unsuccessful civil or criminal proceeding with malice, without probable cause, and with resulting damages. So there are some elements that you need to bring a claim for malicious prosecution. The first one is that the defendant in the case must have initiated the proceeding without probable cause, with malice, and the proceeding must have been terminated in favor of the plaintiff. And you also have to show special damages for civil proceedings. So now I'm going to go back to the first element and give you some details. The defendant must have initiated the proceeding, whether it was criminal or civil. It's important to understand that a malicious prosecution action can result from the initiation of either a civil or a criminal proceeding. If a plaintiff is bringing a malicious prosecution claim alleging that a criminal proceeding was instituted previously, the fact that it was instituted at all is enough for them to meet this element. For example, in a North Carolina case in Cook v. Lehner, the plaintiff was arrested for writing a check without the sufficient funds to pay, with the intent to defraud the receiver of the check. But in fact, the defendant knew the entire time that the plaintiff never had the money to pay for the check, therefore there was no actual act of fraud to begin with. The charges were obviously dropped, and Cook brought the claim for malicious prosecution. The fact that he was originally arrested to begin with was enough for him to show this element that the defendant instituted the proceeding. However, if the plaintiff is bringing a malicious prosecution claim for a civil proceeding, the plaintiff must show that the proceedings were instituted primarily for a purpose other than that of securing the proper adjudication of the claim. So for example, in the case of Fowl v. Fowl, the plaintiff was wrongfully and unlawfully committed to a mental institution by her husband at the time, who's now her ex-husband. The defendant knew that she was not insane and had no mental disabilities. The plaintiff claimed that he acted solely through ill will, malice, in placing her in this mental institution because of the difficulty in their marriage. He ended up filing for divorce right after she got out of the hospital. The plaintiff had a viable claim for malicious prosecution because the civil proceeding against her in the first case was instituted primarily for a purpose other than that of adjudicating the claim. So there are two important things to remember with this element, and that is that the plaintiff must have been sued or the defendant must have been the one to bring the criminal charges. If there's no prosecution to begin with, you can never bring a claim for malicious prosecution. We're going to move to the next element, and I'm going to turn it over to Glenn, who will discuss the lack of probable cause.
Thank you, Rachel. As Rachel mentioned, the second element in malicious prosecution is probable cause. And so what is probable cause? It's basically a reasonable man standard. You've got case law defines it as the existence of such facts and circumstances known to the defendant at that time that would induce a reasonable man to bring prosecution. What it doesn't mean is that the plaintiff doesn't have to be 100% confident in his case, doesn't have to be confident that he'll win or that the accused is guilty of the crime. It's just got to be a reasonable belief that the claim is not frivolous. And the court's not going to view probable cause in hindsight. That would be an absurdly high standard to require them to know 100% completely at the beginning. So let's take a quick look at the case Corey versus John Maye of Norwich, a case which turned on the existence of probable cause. In this case, the creditors had a debtor arrested for writing paid in full, alleging that they had fraudulently written paid in full on the back of a check after it had been cashed, and then using that check and paid in full to deny liability under the existing contract. So creditor brought criminal charges. Those charges were eventually dropped, and then the debtors filed a claim for malicious prosecution against the creditors. So the question before the court was whether the creditors, at the time they had those criminal charges brought, if they had probable cause to bring those charges. So we've got a debtor who fraudulently wrote paid in full on the back of the check and then lied about it in a court of law. So based on those facts, the court had no trouble concluding that the creditors had probable cause in bringing that action. So let's take a step back and move on to the third element, which was malice. Now, the simplest definition of malice is a wrongful act intentionally done. And as with a lot of things in law, the simplest definition is not always the one that governs. In the world of malicious prosecution, there are two types of malice. We have actual or express malice, and then implied or legal malice. Now, express malice is the malice that we think about in ordinary terms. Ill will, spite, revenge, kind of like a sinister motive, a complete disregard of the plaintiff's rights. Even if you're pretty sure that someone brought a prosecution against you, did so with actual malice, it'd be very difficult to prove, and proving it in the court of law is a completely different story. The good news is that North Carolina doesn't require a plaintiff to prove this element unless they are seeking punitive damages. Do note that some jurisdictions do require this heightened express malice to bring a claim of malicious prosecution. So if you move out of the state, be sure to do your research if you're considering bringing this kind of claim. The second type of malice is implied or legal malice. This is much easier to prove because it's more inclusive and can be inferred from the lack of probable cause, or basically no reasonable explanation for wanting to bring the case in the first place. Implied malice is all that's required in North Carolina to sustain a claim for malicious prosecution. So now let's take a look at how the malice requirement is played out in an actual case. And we'll take a look at the case of Johnson v. Smith, which is an Alabama case. And Alabama, like North Carolina, only requires the implied or legal malice to sustain a claim. So in Johnson v. Smith, Johnson brought a claim against Smith to recover money owed for paint. Smith didn't pay for the paint. He said the paint wouldn't dry and he wasn't going to pay for defective paint. The manufacturer got involved in the first suit, and that claim was settled when the manufacturer issued Smith a check, who then paid Johnson. Johnson then filed a second suit against Smith, and this one is for unpaid automobile car parts. That case was reversed, and basically, that case was resolved, and then Smith brought a claim for malicious prosecution against Johnson for bringing that second suit, saying that he never owed Johnson any money for the car parts, that Johnson knew that, and that he brought the claim anyway. So the court was presented with the question of, did Smith properly allege the malice requirement to sustain a claim for malicious prosecution? And the court said yes. The court found that Johnson had no reasonable reason for bringing that second cause of action, that Smith never owed him for automobile parts, and that Johnson knew this at the beginning and still decided to file the claim anyway. And that's the type of malice that's going to support a claim for malicious prosecution. So let's move on to discuss the next element, which is the proceeding terminated in favor of the plaintiff. As with the first element, there has to be a prosecution to support a claim. There has to be a termination of that prosecution to support a claim as well. And the reason is that if the proceedings haven't terminated, it's impossible to know if there is a lack of probable cause or if the plaintiff brought the claim with malice or with not. And so what is required for termination? Full-blown trial is not required. All that is really required is a termination that reflects the merits of the action. On the merits is basically the key to the whole thing. The termination is based on some kind of procedural aspect or something not related to the merits. It's not going to qualify to sustain a claim for malicious prosecution. Now, what constitutes termination is going to vary based on criminal and civil proceedings. We're going to take a look at a couple examples of what will qualify and what won't qualify. So in the realm of criminal proceedings, here are a couple examples. On the left, you'll see of what qualifies. A discharge by the magistrate at the beginning, kind of a refusal of the grand jury to indict, formal abandonment of the procedures, and the like. Now, things that are not going to qualify is if the charge is completely withdrawn, if there's some kind of plea agreement. These types of things don't really reflect the innocence of the accused, so they're not going to qualify. Now, what about civil proceedings? The civil proceedings, a full-blown adjudication of a claim is going to qualify. A summary judgment motion, that's going to qualify. Once again, it's getting back to what is on the merits and what is not. A mere procedural dismissal, not going to qualify. Now, there's kind of some hazy ground about, what about a voluntary dismissal of the claim? If the opposed parties agree to go ahead and dismiss the dispute. Jurisdictions differ. Some jurisdictions believe that this dismissal reflects negatively on the cause of action, and it can lead to an inference that the plaintiff, there was no probable cause in the first place. So some courts will allow that to sustain a claim for malicious prosecution. Other jurisdictions take the approach that it merely places the parties in the same position they were before, and it shouldn't sustain a claim. North Carolina takes the former approach and says that a voluntary dismissal of both criminal and civil proceedings is enough to sustain a claim for malicious prosecution. And then to discuss the final element of damages, special damages, I'll turn it back over to Rachel.
Thank you. Okay. The last and final element of malicious prosecution is that special damages must be proven. However, this is only relevant and important if the prior case was a civil case. The reason that for criminal it's unnecessary is because an arrest has already been made, and so the person's liberties and property were already affected. It's not as easy in civil cases, therefore they have to go and prove an extra damage. The plaintiff must show in a civil case that there was some arrest of their person, seizure of their property, or some other special damage. An example of a special damage was shown in Alexander v. Alexander, which was a North Carolina case. The defendant in this case took out a 50B domestic violence protective order against the plaintiff with no evidence of domestic violence. This type of protective order substantially interferes with a person's liberties and rights and their property. So that's considered a special damage and would be sufficient to fit this element of a special damage. There are examples of damages that are not considered special and would not be significant enough, and even if the other elements of malicious prosecution were met, they would still not have a viable claim and could not bring the action. These include embarrassment, inconvenience, loss of work and leisure time, stress, strain, worry, things of that nature. And the reasoning that these are not substantial enough is because in most litigation for any type of claim, litigants feel these type of emotions. Therefore, it's not considered a special damage, and they would not have a viable claim. So now we're going to switch gears a little bit and move on to computing damages. So we're going to assume that all of the elements were met and the person has a viable claim. They may pray for compensatory and or punitive damages. Punitive damages is much harder to prove, and it's often denied by the courts. But I'm going to start with compensatory damages. The plaintiff must show that the defendant in the previous case brought the claim with legal malice. And as Glenn mentioned earlier, legal malice is also referred to as implied malice and may be inferred by the jury from a want of probable cause. If the plaintiff is successful in bringing the claim, they're usually awarded compensatory damages. Now, punitive damages, on the other hand, is much more difficult because actual malice must be proven by clear and convincing evidence. And it's only awarded in conjunction with compensatory damages. Punitive damages were denied in the Cook v. Lehner case, which I discussed earlier, but just to refresh your memory, that was the case where the plaintiff was arrested for making out a check without sufficient funds to pay. Even though the plaintiff prevailed in the previous criminal action, and there was evidence to prove that the defendant falsely prosecuted him knowing that he never actually defrauded them, the court found that this was still not enough to prove actual malice, and punitive damages were denied. The plaintiff did prevail and did get compensatory damages. Courts will allow an award for punitive damages when there's sufficient evidence of malice, willful, and wanton conduct to support the jury's award for punitive damages. The jury's award for punitive damages were actually put into question in the Scarborough v. Dillard's case out of North Carolina. After much litigation and appeals, the court finally did allow the jury's award, but I'll give you a background on how long this took and how difficult it was to get the punitive damages. The plaintiff in this case was a part-time worker at Dillard's in their shoe department. He accidentally allowed 2 customers to leave without paying for their shoes. He was approached by his manager, and he apologized, took full responsibility for what he did, and offered to compensate the store for his mistake. The manager didn't react as nicely and made direct threats, threatening that he was going to have him arrested for embezzlement and ruin his job, his full-time job at a local bank, if he did not provide the names of the women. He didn't know the names of the women, and it was an accident, so he could not provide that information. The end result was that he was arrested for embezzlement in the atrium of the bank that he worked at. He was found not guilty criminally, and he brought this claim for malicious prosecution. The jury actually awarded him compensatory and punitive damages. However, 4 years later, the court granted Dillard's motion for a judgment notwithstanding the verdict. The plaintiff appealed, and the court eventually found that there was sufficient evidence of actual malice. In addition, because the defendant in this case was a company, which was Dillard's, the court also had to find that Dillard's officers, managers, or operators had participated in or condoned the conduct giving rise to the punitive damages. In this case, since Dillard's manager was the source of the threats, it was sufficient, and the jury's punitive damages were reinstated. But needless to say, even when punitive damages are awarded, they're often contested and can be the result of lengthy litigation. I'm now going to turn it over to Joe, who's going to discuss the difference between malicious prosecution and abusive process.
Thanks, Rick. All right, you've heard us mention a couple times throughout the presentation a separate cause of action called abusive process, and I want to take this opportunity to give you the ins and outs of that cause of action so that you can understand it in relation to malicious prosecution and understand the differences that are between the two causes of action. There are a few definitions of abusive process floating around right now in the case law, and I have a personal favorite because it's the most self-serving statement I've ever heard. But abusive process is the misuse of legal process for an ulterior purpose. So not very helpful there, but I was nice enough to get us the second definition, which is a little more insightful, and it's stated that the misuse of process, no matter how properly obtained, for any purpose other than that which is designated to accomplish. So it's a little more helpful. Now, as I've said, abusive process and malicious prosecution are very similar claims, and they're almost always pleaded together. And for good reason, because most often the facts that can support one are often sufficient to support another. But there is one major difference. As we've discussed, in malicious prosecution, we are concerned solely with the initiation of process. There's no consideration as to any other process for either party past the initial, so no discovery motions, nothing like that. Abusive process, on the other hand, can be claimed for any aspect of process and even on a claim that may be initially valid. And furthermore, for abusive process, it can be brought in relation to a proceeding that is still pending, so there doesn't need to be any finality to the situation. That's really the main difference, but I'll give you a little bit more about abusive process so that you have a better understanding of the claim. The case most often referenced to discussing exactly what abusive process is Standback v. Standback. And in that case, the court cited an article from Professor Robert Byrd, and it articulated that there are two elements necessary in order to file or state a claim for abuse of process. The first is having an ulterior motive, as you saw in the definition, and also that there's an act in the use of process not proper in the regular prosecution of the proceeding. Essentially, an act being used inappropriately. Now, both of these elements are present in malicious prosecution, but you'll see them in different ways. The act requirement relative to malicious prosecution is inherent in the filing of proceeding in the first place. As we've stated, there has to be a prosecution in order for there to be a claim of malicious prosecution. So, those two are very, very similar together. And the ulterior motive element in abusive process is very well mirrored by the malice requirement in malicious prosecution. So you can see that the two claims are substantially similar, but there is that one difference of exactly what part of the process you are focusing on. And this just can give you an example and an explanation of the differences in the two claims. And it's back off the go.
Now we wanted to take a few moments to look at misuse of legal proceedings in the context of debtor-creditor law. Now, these two causes of action, malicious prosecution and abusive process, often arise in debtor-creditor law because of the extreme lengths that some creditors will go to try to collect a debt. From the very beginning, I want to make it clear that instituting a legal proceeding or abusing legal process for the primary purpose to collect a debt is not okay and is going to open you up and subject you to liability. We're going to take a look at the case Culpepper versus Smith, which is a case out of Arkansas that really illustrates the interplay of these two causes of action in the realm of debtor-creditor law. So what are the facts of the case? Briefly, Culpepper is in the swimming pool business, and he had a contract with Smith to install a swimming pool in their backyard. They shook hands, Smith paid a deposit, and work was set to begin. Then Smith goes to Culpepper and says, hey, can we delay a little bit? Delay. Culpepper's like, that's absolutely fine. Smith comes back later and says, you know what, my wife doesn't really want a swimming pool, and so I want to go ahead and cancel the contract, and by the way, I want my deposit back. Culpepper was not going to agree to a breach of the contract or a cancellation and refused to return the money. So Smith turned around and hired an attorney, and together they sent a very demanding and threatening email to Culpepper saying, if you don't refund the deposit, we're going to file criminal charges against you. Culpepper still refused to return the money. He said, I'd be happy to install the pool. I'm not going to cancel the contract. So Smith and his attorney then went to the prosecutor, and Smith told the prosecutor that he could produce witnesses of people who could say that they have been defrauded by Culpepper, that he refuses to honor contracts and the like. Relying primarily on Smith's stating that he could bring forth witnesses, the prosecutor had Culpepper arrested on charges of theft by deception with the intention to deprive Smith of his property. At the same time, Smith brought a civil breach of contract claim against Culpepper, and in that suit, Culpepper responded with the counterclaim of malicious prosecution based on the criminal proceeding, which resolved the charges had been dropped. So the question then is Smith and his attorney, can they be liable for Culpepper's claim for malicious prosecution and abusive process? Let's take a look at both of the people individually. So Smith is the client. His defense to the claims of malicious prosecution is like, hey, I'm just an uneducated layperson. I don't know anything about the criminal process. I'm relying on my attorney to tell me that. I didn't know it was illegal to file criminal charges to collect a debt. Court didn't really buy that. Court said, ignorance of the law is not an excuse and you can be held liable. The court did point out, though, that Smith could have had a defense if he had fully and truthfully and given a complete disclosure to his attorney and then acted in good faith on that advice. However, in this case, Smith didn't do that. He never told his attorney that he had ever asked for an extension under the contract. And he also lied about the fact that he produced witnesses to testify about Culpepper's prior acts of fraud. He couldn't do that. And so the court allowed that part of the case to go before the jury to determine if Smith could be liable for this. Now, what about Smith's attorney, Fix? Could he be liable? Fix tried to defend himself, saying, "I'm just advocating on behalf of my client. I'm the middleman, passing along information. I shouldn't be held liable." Court didn't buy this argument either. They said that he had an that he affirmatively participated and requested the initiation of the proceedings, and thus can be held liable for malicious prosecution. The court specifically highlighted his ethical duties as an attorney, and said that he should have known that it was unethical to use the criminal process to coerce a payment of money. So if we take a step back, what can we learn from this case? We can learn 3 things. First, like I mentioned, it's not okay to bring or even threaten to bring criminal proceedings against a debtor for the primary purpose to collect a debt. We also learned, secondly, that if a client makes a full, fair, truthful disclosure and then relies on the information, he or she may have a defense to a claim of malicious prosecution. And third, we learned that an attorney can be held liable for malicious prosecution. To provide more detail on this, I'm going to turn it over to Shelley Bleda.
Okay, so up until now, we've been discussing malicious prosecution on a more general level with respect to the client, but now we're going to discuss in this section how the attorney can play a role in malicious prosecution and how you, as an attorney, could possibly be exposing yourself to liability without even realizing it. So the first thing I'm actually going to do is turn it over to Joe very quickly to discuss a few points about professional responsibility. But I'll be back.
As lawyers, we aren't just concerned with the issue of liability for clients and ourselves. We also have an entirely separate regard for professional responsibilities to consider as well. Now, most of the time, these kinds of issues, it's going to be pretty easy to tell what kind of conduct is allowed and what kind of conduct is not. It's not always going to be the case. Some point and sometime in your careers, you're going to run into a gray area where you're not sure whether the action you're wanting to take is permitted by the rules. Now, this kind of issue can arise in any kind of cause of action, and especially so for malicious prosecution, abusive process. They're even more treacherous because of the type of claims that they are. And there's, a number of rules that can cursorily apply to this kind of cause of action, but there are 2 main rules that I want to highlight in the North Carolina Rules of Professional Conduct that really speak to the claim of malicious prosecution. The first one is Rule 3.1, and I'll just read it verbatim. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or an reversal of existing law. Now, immediately, you can see the relationship of this rule to malicious prosecution. And as we all know, in relevance to 3.1, we also have the Civil Rules of Proceedings of Procedure that provide for sanctions under Rule 11 for doing so. And furthermore, under Rule 4.4, stating, in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person. Again, this is very relative to malicious prosecution because it's exactly what you're doing. You're setting up a claim that doesn't have a basis. You're just angry at the person and taking it out on them using the legal process. Now, admittedly, discussing these rules in the abstract is a bit difficult. So I have a TV clip that we're going to show in just a minute that will hopefully kind of ground some of these issues for you and show you how they can arise in actual practice. Now, there's so many TV dramas for legal dramas now that I can't even count them all. And I personally can't even watch Law & Order anymore because they break too many laws per episode. But I have a clip here from Suits, and it demonstrates how a malicious prosecution might arise and how hard the line in the proverbial sand of conduct can be to find. So, to give you a little bit of background before we hit play, prior to this clip, the episode demonstrates a situation where a secretary brings a sexual harassment charge against her CEO, and during the course of the episode, the CEO does some witness tampering, pays off a witness, and also destroys some evidence so that the plaintiff's lawyers can't find other witnesses to testify with some other things. And the clip you're about to see is the plaintiff's lawyers in dealing with what they've discovered and doing the best they can for their client. And when we're done, I'm going to ask you what you think about whether or not such an action was appropriate. Essentially, the plaintiff's lawyers using the threat of a claim, in this case a criminal prosecution, in order to leverage a settlement in their civil suit for their client. Now, it might not be as entertaining for us in the future, but it's clear how you could see this type of situation arising. And this question has actually been addressed by the North Carolina Bar, but I want to get your opinion on whether you think what they did was appropriate under the rules, if I have any volunteers. Okay. Well, the short answer is yes, actually. Exactly what they did in this episode is permitted under the rules. The ethics bar demonstrated there's two elements in basically leveraging a settlement by threatening criminal procedure suits. And two elements are that the two actions have to be related to the same subject matter. You can't have a civil suit and then threaten criminal proceedings on a completely separate issue. They have to be related. And the second is that the lawyer dealing with both the criminal and the civil suit has to have a good faith basis for both suits. And Barr has stated that if both of those elements are met, you can use the threat of criminal procedure as a mechanism for leveraging a settlement. Now, this wasn't always the case. In 1997, the North Carolina Bar Rules of Professional Conduct were amended, and they explicitly took out the prohibition that kept this kind of action from being taken. Now, as one final point, I want to talk about just being a zealous advocate. The bar recognizes the dilemma that lawyers face in having to abide and handle the line of what's professional conduct and what's professional misconduct, in accordance with also being a zealous advocate for your client. And generally, they recognize that it is entirely necessary to be a zealous advocate, and they're not going to scorn or have some kind of disciplinary action against you for playing the game and using the rules legally to your advantage. But so long as an attorney is unaware of a client's improper motives relative to malicious prosecution, an attorney will not be held liable or punished for malicious prosecution in using it and presenting a claim, so long as there's probable cause and all the elements that would not have made this claim obviously frivolous. I'll give it back to Shelley now. Thanks.
So if an attorney doesn't abide by these professional responsibilities that Joe just discussed, he or she may be held legally accountable for his or her participation in a malicious prosecution action. So I'm going to go through the elements of what is required to find that an attorney is liable. A plaintiff will have to establish that the lawyer procured the initiation of the proceedings without probable cause, primarily for a purpose other than bringing an offender to justice or assisting a client assert his rights, and with the prior proceeding terminating in favor of the plaintiff. And you'll probably notice that these elements are very similar to the elements that we discussed earlier with regards to the client being charged with malicious prosecution. And the reason we've actually laid the elements out a second time is to demonstrate a very important point. And that point is that the plaintiff has to demonstrate all of these elements with respect to the attorney, in addition to with respect to the client. So it doesn't logically follow that just because your client has done malicious prosecution and just because your client is liable, that does not mean that you automatically are, just because you're their lawyer. So as we walk through all of these elements, we're actually going to talk a lot about these conversations that are going to happen between the attorney and the client. They become very important. And so the first question I hope that pops into your mind is, what about client confidentiality? I'm an attorney. I'm not supposed to tell what my client tells me. Well, here, it's actually excused by North Carolina Bar Rule 1.06b6. In a situation where an attorney is being charged with malicious prosecution, is being sued for malicious prosecution rather, they are allowed to reveal information that would otherwise have been privileged, because it falls under this exception where the client's conduct is involved and the attorney is being charged with, or the suit involves the attorney's representation of the client. So it kind of falls under that blanket, so you're kind of safe in that situation. So I just wanted to address that before we go into the elements. So I'd first like to dive into more detail on the first element, which is that the lawyer procured the initiation of civil or criminal proceedings. An attorney procures a malicious prosecution only when he counsels his client specifically to initiate a proceeding without the client first seeking counsel about such initiation. And these are all very important. To illustrate this point, I want to walk you through two scenarios. Okay, in the first scenario, the client asks his attorney for open-ended advice on the best means to pursue a private advantage. The attorney specifically advises him that the best way to get the desired result is to institute criminal proceedings. In this case, since the plaintiff was only asking for general counsel and never specifically brought up the idea of criminal proceedings, the first element would be met, and the attorney here is procuring the initiation. In contrast, in the second scenario, the client tells his attorney a set of facts and asks the attorney, given these set of facts, does it justify a criminal proceeding? Because that's what I want to do. And the attorney advises him, okay, if those facts are true, then yes, they justify a criminal proceeding. In that case, it's the client that brought up the idea of filing the criminal proceedings. So the attorney is merely advising him that that's okay, and here the first element would not be met because it wasn't the lawyer that initiated it. So I'm sure you're thinking that this is a really fine line to walk, and it is, and it's just, we thought that this was very important because it's a very slight distinction, and you should just realize that even being the first to bring it up might actually be used against you later on. But not to worry, because a plaintiff still has to prove a lot more elements for you to still be held liable. So the second element is that the attorney must have initiated the proceeding without probable cause. The same objective standard for what would qualify as probable cause is in play here, except for one very important additional protection for attorneys, and that is that attorneys are entitled to rely in good faith upon statements that are of fact that are made by their clients. And the rationale for this rule makes complete sense, because as attorneys, we're supposed to be the advocates of our clients, and it would create a conflict that would just get in the way of our fiduciary duties to our client if we were constantly questioning them and second guessing them because we're afraid of potential liability. And I think the courts recognize that. So the third element requires that a plaintiff show that the attorney instituted the proceedings primarily for a purpose other than bringing an offender to justice or assisting a client assert his rights. This requirement, again, recognizes that as attorneys, we want what's best for our clients, and we owe them a fiduciary duty, and we need to do everything we can to get what they want and what they're seeking. This element can kind of be considered the attorney equivalent to the malice requirement, which we discussed earlier. So it presumably implicates the intent of the attorney and calls for a factual inquiry about all of the information that the attorney had at the time. Now, because this idea of attorney liability, especially in North Carolina, is relatively new, we really don't honestly know exactly what a court is going to require a plaintiff to show that an attorney had an improper purpose. But presumably, we're going to assume that this is a very high standard to meet, because courts have made several points in dicta just saying that you need to protect the attorney, and the attorney is a zealous advocate, and we need to be very protective of that. So we personally think that this element's going to be very high, and it's going to be a tall order. The last requirement is that the prior proceeding ended in favor of the plaintiff, and this is the only element that doesn't require a separate analysis for the attorney, because it has nothing to do with the attorney, it has nothing to do with the actions of the client. The same standard is used for attorneys as is used with clients. Recall that the key to this element is that the termination of the prior proceedings means a termination on the merits, and so a dismissal purely for procedural defects is not going to cut it. So we're going to discuss a slightly related topic, and I'm going to turn it back over to Joe, who's going to discuss law firm liability.
All right, so up until this point, we've only really addressed liability as it would apply to the individual attorney and to the client. But that should raise a flag in your head, or at least another question in your head. Can the firm partnership in which the attorney works for be held liable for the actions of the individual attorney if they had knowledge or some kind of participation, if they did not have any knowledge or participation in the attorney's conduct? And the simple answer to this is no. and this rule was handed down in the Jackson v. Jackson case. A firm will only be liable if the actions of the individual lawyer are considered to be the ordinary course of business of the firm, or for some reason he was granted authority specifically to do it. And this falls into the same kind of scheme, same theory of respondeat superior or vicarious liability. While filling advice and filing claims or criminal charges are, of course, going to be the ordinary course of business, I mean, that's just what lawyers do, the court has specifically addressed this issue and said, while filing claims is the ordinary course of business, doing so without probable cause, with malice, and meeting all the other elements of malicious prosecution, that makes doing so not the ordinary course of business, and therefore inherently a malicious prosecution claim can't be, or a charge against an attorney for malicious prosecution can't be under the ordinary course of business. So there has to be some kind of showing, if you want to get into the pockets of the other lawyers, that there was participation on their part or knowledge on their part. Otherwise, you will not be able to impute liability against them.
So a case that was handed down earlier this year by the North Carolina Court of Appeals that speaks directly to this topic of attorney liability is the Chidneys versus Chidneys case. This case involves an initial dispute between a husband and a wife, which should not be very surprising at this point. In trying to divide up their things after they separated, the husband filed charges against his wife for criminal trespass when she went back to their home to get her stuff, even though they clearly had an agreement to the contrary. So this resulted in the wife filing a malicious prosecution action against her husband and against the attorney. The husband was the one who actually filed the criminal proceedings, not the attorney, but the husband claims that the attorney specifically counseled him to file false criminal charges against his wife. Well, the district court dismissed all of the claims against the attorney, saying that she had not stated a claim because the attorney hadn't been the one to actually initiate the criminal proceedings. But she appealed, and the Court of Appeals heard this case where they have to decide whether the plaintiff has sufficiently stated a cause of action where the attorney wasn't the one who initiated the criminal proceedings but merely advised. So both parties, they've conceded at this point that in certain circumstances an attorney can be held liable for malicious prosecution, but their major point of contention is whether an attorney can be held liable for a criminal proceeding that is initiated by the client and not by the attorney. Now, Joe just mentioned Jackson v. Jackson a minute ago, and that created the rule for law firm liability. And the court found that case to be very informative because in that case, it was also the client that had initiated the proceeding, and although the court didn't specifically address whether the attorney could be held liable, the Court of Appeals found that by distinguishing between the law firm and the attorney, there's an implicit assumption that the lawyer could have been held liable for malicious prosecution in that case, even though he didn't initiate the proceeding himself. So they answer that yes, even if you as an attorney don't initiate that proceeding, you can still be held liable for malicious prosecution, or at least the first element can be said to have been met. So of course the next question that logically follows is going to be what type of involvement on the part of the attorney would be sufficient to amount to the institution. So the court didn't find Jackson to be very helpful about this at all, so it looked into the restatement of torts. So we're going to go back now actually to the two scenarios that we discussed when I went over the general rule for institution for the action. These two exact scenarios are actually right from the restatements, and the court talks exactly, almost word for word about these two exact scenarios, and they came out the same as we presented to you, which is that in the first situation where the attorney's the one who brings it up first, that's initiation. In the second situation where the client came and brought it up first, it's not initiation. So they liked that view, they adopted the restatements view, and that's what they decided. So it created this rule that we now have that an attorney procures a malicious prosecution action only when he counsels his client specifically to initiate a proceeding without the client first seeking counsel about such initiation. So even though this could be seen as an expansion of attorney liability, the court paid lip service to a few very important qualifiers, and I almost think that these qualifiers are almost more important than the actual holding. And the court emphasized that the attorney should never be punished for zealot advocacy. And they made a big deal of this, which is kind of why we think that the standard's going to be high for those other elements. Also, time and time again, the court focused on the fact that the expansion of this doctrine is not going to affect attorneys as long as they're acting in good faith and have probable cause, since those two elements will be met. So this shouldn't be, a really big shock or a scare if you're an attorney that is doing your job in all other respects. It's only kind of bad for you if you already were acting maliciously in your everyday life. Third, the court made clear that each of these elements has to be met with respect to the attorney and proven separately from the client. So they have a few important qualifiers that I think still helps attorneys a little bit. So upon first glance, this case might seem kind of scary, but if you consider the procedure, all this case really does is say that the wife has stated a claim. It doesn't say that he's liable or that the attorney is actually liable. It's not informative in the least about what they would call, where that line of liability is at all. So we can kind of calm down a little about this case. So while all of this discussion is extremely important, I thought that having a perspective from the industry would be very helpful to see how these liability concerns are applied on a day-to-day basis. Allison Bost is the Deputy General Counsel at Womble, Carlisle, Sandridge, and Rice. She supervises the team of attorneys and paralegals that advises the firm on all legal issues that could potentially create liability for the entire firm. Womble Carlisle is a large business large business law firm with 13 different offices, and they do most general corporate work, and they represent a lot of creditors like large businesses and banks. We were lucky enough to have Allison video conference with us earlier this week to discuss her take on malicious prosecution and some possible liability issues that it presents. And we'd like to cue some footage from our interview to let her explain herself all of the ways that a large firm manages liability.
That's not something I have to be. But the broader issue is law firm when we're staff clients.
Absolutely. Actually,
things that big law firm heavily look at this law and every day that we get a lot. You email an officer firm. Email will. I'm on a serves. Get malpractice issues or that on and relevant for the entire firm needs to know that, communicate. Also have meetings where you so conferencing, group meeting place. Recently been invited a couple of different by video conference topic that they but that's a good in their relevant area on the ball is at least twice a year full CLE class for by video conference travel and issue my desk also authority first this is about our and we do and just CLE to keep their lives. So it's a nice to our kids, but also from a keeping them up to date for clients. I attend to give lunch. More people want to do this. I've heard recently, and you can set up a group and I for issues that we want to Twitter feed just here's a link to an article, here's handle that. So who don't like to be liberators.
You also mentioned.
Yes, thank you. I will tell you, staff as in staff often have the first when a client calls in and get is, and we need to stand this particular ask someone for myself or one of my physically each of on a particular staff person so they could ask questions entire staff alert that would be nervous. Just wanted everyone to use that for if they wanted to teach on valuable physics. The program was very well. The whole thing is asking the question on the phone, but they're thinking, oh, I should, whatever. Just showing up in person to you about issues of what we do.
You mentioned communicating of malicious data in line with their clients. All the clients that help a trader.
It's an opportunity. Normal COE twice a year. Valuable. Clients range and go on. It's free. Clients process stuff. The best secret case data claim of a complaint. Liable to stress client privilege that conversations with clients or clients. We want lawyers about the not but then the lawyer through the facts and using your as a question full of was going through a divorce action. My guess is her had learned that she was working and came at it and might have done or view valuable to and he I can't do a good job for soul. Everything about so that and on to let soul. So you already signed there and I'll give you estimates about a husband. It's talking to the judge and the reader's there. Do it.
And I guess with us of the kind of policy that about it and for
actually I'm really proud of it. I've been very sick of it. Policy. It says in our firm, if you see relationship or concern, I mean, we have lawyers play this role, but or gave the client, I think oh my God, enough is available to our clients. Right. The goal is to find and bring what special to bear on that lawyer. Or to whoever. We don't go out. Shelley came to what we're going to do. That'd be good. Telling me about her supervisor made a mistake. Mistakes on purpose of the human condition never means damage a client's rights. Because there's a lot of pressure to get it in quickly. It's good. We've been very successful to become early news. Could have been work on much better. A group of I've talked about the CLE conference, practicing, been successful and tout this. The unique thing about our firm culture, we help you. All firms have necessarily need to do it. A alliance and supporting us in a way that's as scary as it be. I mean, just try to help.
My other group members. Well, thank you. I really appreciate it.